Good morning, everybody. Before I begin, y'all already know the routine. Hit that subscription button and pound that like button. Pound both of them buttons right now before I even start. I'm seeing a lot of views on some of my videos, but I don't see enough likes. Come on, y'all, get these likes up, man. Come on. That helps me out. I really appreciate that. I'm going to give y'all a second to do that, man. Go ahead. All right, now I'm just going to jump right into this. Okay, so the title of this video is I'm going to show you how to draft a motion to suppress. And I'm going to explain to you why you're drafting this motion to express. A motion to suppress. The motion to suppress is based on this principle right here. Where there is a right, there is a remedy. Wherever you have a right, you have a remedy. Okay, under the state constitution and the federal constitution, you have a right to be left alone. There are two exceptions to your right to be left alone. And that is if a police officer has reasonable suspicion or probable cause. Those are the only two exceptions, or consent. Well, three exceptions, I'm sorry, and consent. Those are the only three. So if they do not have a lawful purpose, meaning your consent, reasonable suspicion, or probable cause, and they either detain you or arrest you, and as a result of that unlawful detention or arrest, they seize some type of evidence from you, and they intend to use this evidence as a basis for arresting you, even though they never had probable cause to arrest you to begin with, or reasonable suspicion to detain you to begin with. But they still want to use that evidence against you. You can move to suppress that evidence because in the process of them obtaining that evidence, they violated the Fourth Amendment. And that is your remedy. The exclusionary rule is your remedy when they violate the Fourth Amendment. So let's go here. All of this stuff is easy. Anybody can type this stuff up. Anybody. This is about 99, I'm going to say about 98% of all of your motions, anything you file in court, especially a motion, they're going to be, it's going to be just like this. Is whether if it's in municipal court, you're going to put municipal court of whatever county and the so-called state. If it's in district court, you're going to put district court of the county or whatever, and then you're going to put the state. And then if the state is alleging to be the plaintiff, you're going to put the state's name first, and then you're going to put John Doe or your name second, the alleged defendant, so on and so forth. And then you're just going to do this. This is all you're going to do. Made an error right there. Let me correct that. I'm gonna show you how I do my stuff. You don't have to do yours like this, but this is how I do my motions because I want these people to know that I know what the hell I'm doing. Now they will test you, just to let you know. They're gonna try to test you and see if you know what you're doing. We're gonna highlight that, and I always like to do this. This is one of my practices that I started doing. Let me take this. I don't really like that no more, so I'm gonna take that underline out. And let's go to an insert, and I'm gonna put a footnote right here. All right, and this footnote explains or gives the it cites the authority for me bringing this motion to suppress. A criminal defendant may also move to suppress items seized pursuant to an unlawful arrest as fruit of the poisonous tree. The exclusionary rule bars the admission of items seized during an unconstitutional search. So when they say unconstitutional, they just mean unlawful. That's all they mean. And then I have the Supreme Court case right here in support of my argument. Let's go here. Let's make this smaller. We're going to make this until about 11. This is how I do my stuff, y'all. Y'all don't have to do this. This is just how I do mine. I'm very detailed with my work. That's backwards. Let's go here. All right, because I want them to see this. Now, you can. Here's another way you can do it. Let me go right here, right quick. Right here. So if you're in Alabama, you can type your motion up. You can use this rule right here. All of the states do this, by the way. All of the so-called states, they do this. They have this in their rules of criminal procedure, unlawful search and seizure. So right now you're about to see me draft this motion a little bit more, actually. So this is how I title my pleadings. This is how I start off pleading my case. Here's the typical right here. Comes now. And I put this in. We're going to say John. Oops, spelled John wrong. And I always do this hereinafter. Who am I going to be? We're going to say the, if you want to get, I'm just keep this simple. I'm not going to confuse anybody. So I'm going to just keep this simple. So I'm not going to even put anything hereinafter. I'm going to leave that out. We're going to say John on a special appearance. Because these people, they think they can just do whatever the hell they want to do, y'all. Under duress. And we're going to say pursuant to, this is the authority that I'm using. Right here. This is the authority that I'm using. So we're going to put that right there. Let's see. We're going to make this. Let me change my colors. This is how I do mine. I'm sorry. I don't want to make this too long, but this is just how I do mine, y'all. Might make it a little smaller. Yeah, I'll make that a little smaller. Do that. Might make that a little smaller too. Yeah. Now I like, let's go here, because I like for my stuff to be spaced out, like for my shit to look good. This is just, the reason why I'm doing this to let people know, because, there are some people on my channel who they think that I don't know what the hell I'm doing. Some of them think that I don't know what the hell I'm doing. But I do. I know what I'm doing. All right. We're going to say to suppress. All right. Let me see. John comes now. John in a special appearance under duress pursuant to Wong versus United States. Blah blah blah. To. Whoops. That's too small. Make that might be too big. To suppress all evidence sought to be admitted. All evidence sought to be admitted against the alleged defendant. I think that's going to be my name right there. Yeah, I'm going to do that. That's what I'm going to do. And I'm going to capitalize this because you always capitalize proper nouns. And I know y'all wondering, like, why is alleged defendant capitalized? Because after this here, I'm going to use it right here. I'm going to show you what I'm talking about. Hereinafter, alleged defendant. There we go, right there. So I would not, like throughout the entire use of this document, I would not be referred to as John anymore. I'm going to be referred to as alleged defendant. That's why alleged defendant is capitalized, because I'm being very specific with who I'm talking about. Under, let me see, to suppress all evidence sought to be admitted against the alleged defendant as a result of the fruit of the poisonous tree doctrine. Let's see. All this stuff is easy. Anybody can do this stuff. Anybody can do this. Now they're gonna want to know what I'm talking. I'm gonna capitalize all this. Well, no, I'm not. They should know what a special appearance is, so I'm not gonna do that. So comes now, John, hereinafter alleged defendant on a special appearance under duress. Let me put and under duress. And under duress, pursuant to Wong Sun versus United States, blah, 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 to suppress all evidence sought to be admitted against the alleged defendant as a result. Let me see. Should I make it? I'll leave it like that. I'll leave it like that. And then I like to do it like this. In support of this motion, the alleged defendant states the following grounds. And this is all you do, y'all. Or you can say a ver. I like a ver, so I'm going to use a ver. A ver is the following grounds. I also do it like this. I make this into probably about, it's probably going to be about 11. Yeah, I make that an 11. The alleged defendant avers the following grounds. And you go down, you press 1, and you have your first ground. And I'll say something like this. Anytime you're filing a motion to suppress, in my opinion, I personally would file an affidavit in support of this. I mean, the only thing that I would do, I would say something like this. Let's go. I'm going to show you what I'm talking about. This is what I would do. The alleged defendant contemporaneously files an affidavit let me see, what should I call this? I'm freestyling right now, y'all. The alleged defendant contemporaneously files an affidavit. We want to say affidavit of John Doe. Of John. You can put John Doe, whatever. Here's what I'm going to do. Just so I don't confuse y'all, I'm going to go ahead and put John Doe right here, so I don't confuse anybody. And I'm going to put it right here too. That's just so I don't confuse anybody. Contemporaneously files an affidavit. We're going to say the affidavit of John Doe and incorporates. I be typing so fast, y'all. incorporates same herein by reference. So what this basically means, it incorporates same herein by reference. It's going to say, it's basically you saying like you're going to and incorporates same, meaning the affidavit, the same affidavit herein this motion to suppress. So basically I'm incorporating the affidavit herein my motion to suppress by reference to the affidavit. That's what I'm doing. And what you would do is you would type an affidavit up. The affidavit needs to be based on firsthand knowledge, and you need to be competent to testify. And in the affidavit, you need to only talk about everything that is relevant to proving why your motion to suppress should be granted. That's the only thing you need to talk about. So let me see if I can give you a scenario. So let's say you walking down the street. You know, you're just minding your business. You're walking down the street, but you're in, let's say you're in a high crime area or whatever. So the police, you just look suspicious. And they walk up to you and they start asking you questions or something like that. Now, prior to them walking up to you asking you questions, they don't have a warrant for your arrest. They don't see you commit a crime in their presence. And they don't have reasonable suspicion to detain you. So all of this is a consensual encounter. So they walk up to you, they start asking you questions, and you say, I don't want to talk to y'all. You just keep walking, you just keep walking or whatever. And they see something, let's say they see a gun in your jacket or something like that. They don't actually see the gun, they see something bulging out, or whatever, but that could be anything. But anyway, so and you say, I don't want to talk to y'all, just leave me alone. And they just rush you, they grab you, and they just start searching your person. And they find this gun on you or whatever. And they arrest you and take you to jail for pistol without a permit, or for, we will say pistol without a permit or something like that, or receiving stolen property, whatever it is. We're going to say pistol without a permit. And they take you to jail for that. They had no lawful purpose to detain you prior to them violating the Fourth Amendment. And as a result of that, you can move to suppress that evidence, because in the process of them, like I said earlier, in the process of them finding out that you had this gun on you and you didn't have a permit for it, they violated the Fourth Amendment. Wherever there's a right, there's a remedy. When they violated the Fourth Amendment, your remedy is to move to suppress that evidence, because that is the fruit of the poisonous tree. That is unlawful. They can't violate the supreme law of the land in an attempt to enforce public policy, because that's what they're doing. That's what they're trying to do. They can't do that because that is unlawful. That just defeats the whole purpose of the Constitution if they're gonna let them do that. Let's see. I need to move this one up one more. Yeah, I'm gonna move that one up one more. All right. The alleged defendant contemporaneously files the affidavit of John Doe and incorporates same herein by reference. That would be the only thing that I would say in support of my motion to suppress, because you are a witness. You can testify. Defendants can testify. Whoever has firsthand personal knowledge of all of the facts, meaning they were there, they saw it, and they are competent to testify as to the veracity of what they saw, then you are a witness and you can testify. Let's go down a little bit. All this stuff is easy, y'all. All of this is easy. Now, if you want to insert more grounds, then what you would simply do, you would press enter, and then you would type something else here, whatever you want to type right there, number 2, and then you just keep going and keep going and keep going and keep going. Okay, but me personally, the reason why I would do an affidavit is because, like I just said, you are a witness. And what the so-called judge is going to do is they're going to take the facts of the case, and in that affidavit, you're going to have to plead facts in that affidavit, or aver facts in that affidavit that shows that in the process of them getting that evidence or obtaining that evidence from you, they violated the Fourth Amendment. That's what you're going to have to do in that affidavit. So you need to be very detailed with what you say. And when you are drafting anything, I don't care if it's a civil rights complaint, a motion to dismiss, a writ, I don't care what it is. Before you make this, before you file any paperwork in that so-called court, you need to critique all of the allegations that you are making against these police officers. And you need to ask yourself, okay, if I say this in this affidavit or in this motion to dismiss or in my complaint, can this be used against me? And if so, how can it be used against me? And how bad? If it can be used against me, is it going to be bad? Is it going to hurt my case? Am I going to lose? Or will my motion to suppress be denied? Will my federal civil rights complaint, with the allegations in there, be used against me to grant these police officers qualified immunity or state agent immunity? Always do that. You need to act just like you are acting as counsel for yourself. You need to act as if you are acting like counsel for your defendants who you are suing. This will make your paperwork flawless, because my shit be flawless. This is something I just did this in, like, how long have I been doing this video? How long is this video? This is 22 minutes. Just imagine if I was working on this for an hour or 2 hours or 2-3 weeks, something like. Sometimes that's what I do. My paperwork be flawless, y'all, flawless. And y'all's can too. You just got to go and read. This stuff is not hard. This is it, y'all. This is really it. That is it. The only thing you need to do is just file that affidavit. You need to follow all of those instructions that I just told you earlier in this video in regards to that affidavit, or in regards to your federal civil rights lawsuit, or your motion to dismiss, motion to suppress, whatever. I'm going to go ahead and I'm going to do a motion to dismiss next, but I just wanted y'all to see this. This is very, very easy. So if you like I said earlier, don't let, because this says Alabama or a county in Alabama, don't let that trick you. Okay, the only thing you need to do is just change the names of this document. That's it. And you can leave this pleading, you can leave all of this the exact same way. Other than the fact that you would need to, edit John Doe and put your name, stuff like that, little small stuff. But other than that, you can leave this stuff the exact same way. You just need to change the name of the court, the state and the county, and the defendant. You don't put your name. That's it. And then you would go down. Let me show you. After you do everything, this is how I like to do mine. Put your little signature line in here, just like that. And then you would sign it. I mean, you can go up under here if you want to, and you can put alleged. Let me go put this back. Give me 1 second, y'all. You can put alleged defendant under there and all that stuff, whatever. You can put, the address and so on and so forth, phone number, email address. You can put all that stuff under there if you want, or whatever. Highlight it, stuff like that. I'm going to read y'all this right here, and then that's going to be it, this little section right here. And that's going to be the end for this video. I'm sorry it kind of be, it's kind of all over the place just a little, but as long as y'all are understanding what I'm trying to get y'all to understand, then I don't care. So evidence may be excluded as fruit of the poisonous tree, and then there's the case. In Wong Sun, the court discerned no distinction between testimonial and physical evidence. Okay. However, in another case, in United States versus Ceccolini, it must be some type of Italian name. The court, speaking through Justice Rehnquist, drew such a distinction and stated that a closer, more direct link between the illegality and the evidence is required for testimonial evidence. So if you're trying to suppress testimonial evidence, meaning if you're trying to suppress the evidence of a witness, whether it be a police officer or somebody who was standing on the street that saw what happened, then this is the case you need to read right here. I just highlighted it for you. That's what you need to read. But if you're only trying to suppress evidence such as something that is tangible, like objects, guns, weed, any type of so-called contraband, or so to speak, then this would be the case. That would be the case. Now, there are more cases. There are a lot more. So I would advise y'all to just go and read. And that's going to help y'all understand this stuff. If that helped y'all, I really hope it did. If it did, give me a thumbs up, man. If it didn't, comment below and let me know what you need help with. Okay, so that'll be the end of this video. The Supreme Litigant is out. Peace. Let's get up out of here, man.